Thanks very much, Convener, and good morning. Let me start by placing on record once again my thanks to the Scottish Prison Service, officers and staff for the vital work they do to support people in their care. I know that they do this with compassion and professionalism. And I also know that the committee is well versed in the critical situation facing our prisons. I've endeavoured to keep Parliament updated and informed on this issue. I've now made 3 statements to Parliament alongside my most recent statement on the 16th of May. I've written to this committee and published an associated position paper and information note, and I wrote again to committee when I laid the draft regulations. It is a situation that England and Wales are also facing and taking action on. The Scottish Prison Service has kept its population management strategy under review to ensure the best use of its estate. We have optimised the use of home detention curfew and have increased investment in community justice services. But despite these efforts, the prison population has increased by 13% since the start of 2023, with a substantial increase since March 2024. And as of this morning, there are 8,294 people in custody and in the care of the Scottish Prison Service. It is this sharp and unanticipated rise which is placing enormous pressure on the safe operations of prisons, and urgent action is needed to address this. Emergency release is the only option available to me to do that, which is why I have laid the regulations before us today. This is not a decision I took lightly. I am clear that the legal test to use emergency release is met and that it is necessary and proportionate to respond to the risk to the security and good order of prisons and the health, safety and welfare of prisoners and staff. Those are the principles that I must protect. Public protection is a priority in this process. There are safeguards in place to support the use of emergency release legislation. These are set out in legislation, but just to quickly summarise, Convener, only prisoners serving less than 4 years and who are due to be released within 180 days following the date of the regulations coming into force will be eligible for release. Statutory exclusions apply, including prisoners subject to the Sex Offenders Register and those serving sentences following conviction for domestic abuse offences. I have added further protections so that individuals who have previously served a sentence following conviction for a domestic abuse offence, providing that that conviction is not spent, these people will not be released under this power. Individuals subject to non-harassment orders will also not be released. And a governor veto applies, which allows governors to prevent the release of an otherwise eligible prisoner if they consider they would pose an immediate risk to a specific individual or group if released. Governors will have access to a range of multi-agency information to support the application of the veto, including from police and social work. Convener, let me stress that I recognise victims' concerns about the use of these powers and want to assure the committee that protecting the public remains my absolute priority. We are working with victim support organisations to increase victims' awareness of how they can access information. The regulations name 4 victim support organisations so that they can receive information about the release of a prisoner if the victim in their case has said that they want that. That is intended to support a more trauma-informed approach. Emergency release is not the solution to the prison population crisis. It will, however, provide the prison service with some time and capacity in the short term. This is critical in order to ensure that prisons can still function safely and focus on those who pose the greatest risk of harm. So thank you, Convener, and I'm always more than happy to answer any questions.
you.